Can natural law serve as a limit on judicial discretion when it comes to the Constitution? On this point, I am extremely skeptical. Good luck with that. What rights one deems natural are likely to depend very much on where one is standing, what one's moral or political views are. So, if neither textualism nor originalism nor some theory of natural law or natural rights furnishes a very fruitful perspective from which to interpret these open-ended provisions of the Constitution, what does? Let me close by briefly, I have at least a couple minutes left, okay, by briefly putting forward my own perspective. I believe that most disputes over moral values and the manner in which those values get implemented should be debated and resolved through the political process, rather than those decisions being made by judges, at least through the interpretation of the Constitution. The political process is by and large where we work out our differences over moral values. And so, I'm not a legal positivist in the sense that at least some legal positivists believe that there is a line between law and morality. I don't have that view. But I do think there should be a line between morality and constitutional law. And that the role of judges, at least the role of judges in interpreting open-ended provisions of the Constitution, should be to perfect our democratic process. And let me explain what I mean by that. Two things. First, perfecting our democratic process on the front end by knocking down barriers to equal participation. That includes not only limitations on who can vote, but in our ability to participate as equals in the conversations of democracy. And in this respect, I would submit the recent controversial decision in the Citizens United case is a giant step backwards. Secondly, where there are inequalities in the political process, what courts should do in interpreting the Constitution is try to correct the results of those inequalities. The most notable example here is the role, at least historically, is the role that the Warren Court played in desegregating public schools. It was necessary for the courts to step in during this period because African Americans were almost completely excluded from the political process. They were not allowed to vote throughout the states of the former Confederacy. So we couldn't rely on the political process to ensure equal rights, including in education for African Americans. It was necessary for the courts to step in to redress the consequences of inequalities in the political process. This is basically a theory that at least those of you who are 2Ls and 3Ls have probably heard before. It's a representation, reinforcement, process-based theory of constitutional interpretation, most famously associated with Carolyn Products and with the work of John Hart-Ely. So, my position is that when courts interpret the Constitution, they should, generally speaking, be guided by respect for the democratic process, and that by and large, intervention on constitutional grounds should be justified by the need to redress political inequalities rather than by some conception of natural law.
I have an hour and a half, is that what I have? You just did the whole Constitution. First of all, let's get off the table or put on the table so it's clear certain misconceptions that often are stated about natural law. The enjoyment of these objective human goods are individualistic, but not relativistic. Just because you say, well, I want this, and somebody wants that, and no one can simply say, well, I have my own theory of morality. He's not speaking of natural law. The point of natural law is that it's objectively good for each person. The enjoyment of these goods is individually calculated, but the goods are themselves objectively good for each person. Life, play, knowledge, every person is entitled to pursue those goods by being a person. I mean, end of argument. He's just entitled by being a person to pursue those goods. Secondly, to pursue those goods means that the rights are derivative of the goods, not your appetites. That is, you derive your good, your right to life, from the fact that it is objectively good for the human person, not that you desire to live. And since, under the principle of rational universality, if you claim and understand that something is objectively good for you, not that you just desire it, but is objectively good for you, you have to posit it's objectively good for the other person. Therefore, the other person deserves a right to life also, not just you. And so what comes out of this is a matrix of rights dependent on goods, not appetites. And by doing that, you have a moral matrix of rights, and you actually ground it in something that's not relativistic. Second point, if you have a natural law society where people are free to form the relationships and friendships and knowledges by which they can define their individuality according to the unique mix of all these objective goods, you need to have a free society. You need to have a wide range of social space, unintruded in by the government. Now, the professor said that all the decisions, I'm interpolating all, but he seemed to say, all the decisions that are made by life are made through the political process and it should be open. Nonsense. Most decisions about your life should be made on the private associational level. Government is not instituted to tell you what to do good for you. You are to do good through your enjoyment of the objective goods. And for you to do good, you need freedom. You need freedom. So the more we have the administrative state, the less room. The more the administrative state keeps telling you, you shouldn't do this, you shouldn't do that, we're going to regulate you here, you have less social room to be able to live the objective goods under natural law. It's simply a descriptive matter of fact. It's exactly what de Tocqueville saw in the 1830s. He saw a vibrant social space. That social space now is being intruded upon by politics. We're looking to see who can be the president, who can run my social space. Why are we even doing that? Why are we giving up our own pursuit of the natural law goods to that? Last mistake is that judges can import their morality. No. The point of natural law is that it claims to be an objective morality based on objective goods. It's not just one choice of preferences of a moral scheme over another. It claims to be the best. It claims to be the best. As individualistic it is, it's not relativistic. It claims to be the best. So a judge does not have the right to impose his morality. His morality. By definition, he doesn't have the right to impose his morality. And in our legal system, what we have done is we've channeled through the separation of powers, through the checking mechanism, culturally defined in our own experience, true. It cannot be replicated in Iraq or Russia and so forth. Each one has to have a polity that is culturally attuned, but still allows for the natural law goods to be pursued. What we have done through our mechanism is allow these natural law goods to be pursued. And when we undermine that mechanism through judicial activism, congressional activism, executive activism, when we undermine that, we undermine the social matrix by which we are able to pursue these natural law goods.
I'm just going to sit down, and then perhaps we can open it up for Q&A. I'm sitting down because I think I can be very brief by way of response. 3 points. We live in a pluralistic society. We live in a society that includes people with a variety of moral, religious, and a-religious views. We live in a society with Christians, Jews, Muslims, Hindus, and atheists and agnostics. It is simply not realistic to think that we as a society are going to come to agreement on all matters of basic values. Now, there are some things that, regardless of what moral or philosophical tradition we consider ourselves to be a part of, we can agree are wrong. Those are the easy cases, but there are a lot of issues, abortion, affirmative action, gay marriage, on which that is not the case. Second point, the difficult question is when courts should, at least from my perspective, is when courts should step in on constitutional grounds to supplant the decisions that are made by representatives elected by we the people. My position is that, to put it simply, they should generally be guided by a concern with the tyranny of the majority. They should ensure that the political process is open and that the majority isn't ganging up on an unpopular minority imposing their own moral or religious views on that group. Third and finally, I think, Professor Forte and I agree basically that freedom is a good thing, that our laws should be structured, including both constitutional law and statutory regulatory law, to allow us all to pursue our vision of the good. Where I think we differ is that I am more inclined to believe that affirmative intervention by the government is sometimes necessary, especially with respect to those of limited means, to allow us to pursue our vision of the good. One, I suppose, obvious example is laws prohibiting employment discrimination based on race, sex, and I would add sexual orientation. These are critical to our being able to each pursue our vision of the good. So too, I would say, a society that provides a minimal level of at least subsistence benefits, including health care, to its most disadvantaged citizens. This is necessary to ensure our freedom, because without these things, we cannot pursue our own vision of the good. Finally, and perhaps most controversially, the ability to marry the person who we choose, regardless of that person's gender. This, I would say, is essential to pursuing our vision of the good. Now, I'm not saying that that decision should be made as a matter of constitutional law rather than through the political process. But I take issue with the suggestion that government staying out will necessarily promote freedom, especially for the least advantaged members of our society.
Thank you both, professors. This time we'll take questions from the audience for our speakers.